So we continue the trial of Mr. Medvedev, and he continues to be salty with the judge. I think you'll enjoy this. I want you to focus on three things, and you can use two of them as a drinking game if Artie reviews this video. So anyway, jurisdiction, of course. Every time you hear that, take a drink. Objection. I object. I object to that. Drink every time you hear that. And also pay attention to where he keeps asking for evidence that the laws apply in the first place. Now that is the signature Mark Stevens magical question, they think. They think that there is no evidence that can prove that the laws apply to anyone. So they keep asking that question. What evidence have you seen has been presented that shows or demonstrates or proves that the laws apply to me in the first place? So sit back, relax, and grab your favorite drink and enjoy.
No, you're helping the witness right now.
I do want to say this about Mr. Medvedev. He really sticks to the Mark Stevens script and tactics better than anyone I've listened to. I mean, he's totally wrong in all his positions, but he does apply the Mark Stevens bullshit as it is taught. So, enjoy.
Move on.
Sir, are you on the oath?
Move on.
Sir, you're not being responsive. Are you on the oath?
I don't have to be responsive.
Yes, you do.
Finder. No, I don't. I don't have to answer litigants' questions.
Let it be another reason to appeal.
You may appeal as your right, but you may not conduct this courtroom.
Sir, if you want to prosecute me,
move on.
you can. We can.
You want to do this dance, sir?
If I want to do dissent,
Yes. Would you like to?
I don't understand the question.
Keep talking to me, or would you like to have a trial?
Sir, originally there was no evidence of jurisdiction, and I told you I'm gonna.
I made my ruling on that.
You made your
Now let's
ruling.
Move on to the trial.
You made your ruling regardless of
You're
any
on
factual evidence.
You're on cross-examination now, so do cross-examination.
I do cross-examination. You keep interrupting me.
Sir, you're asking me questions about myself.
Because you're not letting me question the witness. You're not letting me cross-examine him.
Have you ever seen a trial before?
How is that relevant?
Because if you had, you would know that judges make rulings on questions. I made my ruling on your question. I said that the question has already been asked by you to this officer and answered in a way that would preclude your asking the other question you asked about whether he was truthful to his supervisor. So I'm making a ruling that you should move on because you do not have the right to ask the same question multiple times.
Sir, am I entitled to a fair trial?
Of course.
Okay, can I get a fair trial as a conflict of interest?
I don't even know what you mean by that.
I'm just asking you. It's a yes or no answer. Who do you represent here today in these proceedings?
Seriously?
Sir, I just asked you a question. Who do you represent in these proceedings?
I'm not a representative.
You're not representative. So,
Not in the people of the state against you. I
okay.
am on neither side, if that's your question.
Okay, so what are you doing in these proceedings here
I'm the
today?
judge.
The judge, and what's the
Do you know that?
what's the responsibility of a judge?
I'm not further answering your question, sir. This is ridiculous.
Okay.
You can look it up. You can look it up if you need to.
I'm going to ask you one more time. Are you on the oath right now?
You can look that up, too.
So you don't want to respond to my question?
I'm not a witness.
You're the one who's making statements, and you're the one who's assuming burden of proof on the complainant's behalf.
We've already been through that, so let's move on.
So you're not going to respond to my question?
We'll have the burden of proof. I've told you that I have responded.
No,
Move on.
I ask you if you're under oath right now.
And I am not getting into philosophical debates with you.
I'm not debating with you, sir, in no way. I'm just asking questions in order to understand these proceedings and the allegations that are being brought up against me.
Sir, the fact that you're frustrated with my not answering any question you want is of no moment.
Are
Move
you?
on.
I'm sorry. Are you saying
You
I'm
want to
not?
do the trial?
I'm not allowed to ask you questions?
That's right, I'm saying.
I'm not allowed to ask
Exactly.
you questions.
If it has to do with my evidentiary rulings, fine. If you're not clear about something, fine, I'll answer your question.
Well, that's why I'm asking you a question.
That's not the question you asked. You asked me if I was under oath. What does that have to do
Yes.
with the testimony?
What does that have to do with the testimony?
I'm not testifying.
Gee, I'm not asking you for evidence, to present evidence against me. You always keep interrupting my cross-examination of the witness. I'm trying
If I
to...
find the questions improper, I will stop you. Just as if the officer said something that was incorrect or improper, I would stop him too.
See, Stevens doesn't prepare them for moments like this. He tells them, ask questions, ask questions, ask questions, ask questions. And the bottom line is, the judge just says it, they're not required to answer any of your questions.
Again, do you always tell the truth to your supervisor at work?
Sir, when you use the word again, that means you've said it already. Next question.
Are you objecting to my question?
I'm ruling that you cannot ask it.
You're ruling on it.
Yes, sir.
Okay. And the grounds of that ruling?
Because it's been asked and answered already. It's an evidentiary ruling.
I haven't gotten any response
He
because
said he's truthful all the time.
no, he was answering a different question, sir.
How is this different?
Because I haven't gotten any response on this question.
What was this question?
Do you always tell the truth to your supervisor at work?
And how is that different than always telling the truth?
That's the way I conduct my cross-examination in order to get evidence that he's relying on.
So you've already asked the question, does he always tell the truth? The answer was yes. That would include a supervisor, that would include you, me, everybody else that he ever speaks to.
Again, you're leading him.
I'm ruling, I've ruled on it twice now, don't make me rule on it the third time.
Are you prepped or coached to speak to your supervisor?
I'm sorry?
Are you prepped or coached? Are you prepared or coached to speak to your supervisor?
Regarding what?
Regarding any kind of information that you present to him.
And how is that relevant to your traffic ticket, sir?
Sir, the matter is jurisdiction again.
No, it's not, I've ruled on that.
I haven't gotten any evidence of jurisdiction. I haven't gotten any evidence at all.
Again, sir, the fact that you're frustrated by these proceedings is of little moment.
I'm not frustrated. You're just not letting me cross-examine the witness. You haven't told me what evidence you have.
I don't have the evidence, it's the officer's evidence.
So the officer did not provide you with any evidence that he's using against me.
That's your opinion?
Sir, I mean, I sent a motion for, it was a Brady request and discovery. I haven't gotten any response, and now I come here today. I was
Would you
forced.
like a continuance?
Yes, I would like to continue.
Fair enough. And what is it you suppose you could gain by continuance? Because I don't want you to be unprepared for this.
No, I'm getting prepared. The only problem is,
So, sir,
today,
Don't speak over the judge, sir.
Now that you've heard the testimony, which is evidence, testimony is evidence. Now that you've heard the testimony and understood that am I correct, officer, that there are no other documents or witnesses to be called in this trial?
That is correct.
If you need a continuance to prepare your cross-examination for what the officer has testified to, I'll grant it to you, because you told me you were not aware necessarily that today was going to be the date for trial. All you have to do is ask.
sir, I object because the motion for discovery and Brady request was filed enough time in advance.
All right, if you can show me where in the vehicle and traffic law, you get an opportunity for that sort of discovery which you've asked for, I'll be glad to grant your motion.
Sir, you,
See, they're here again, this is something they're not prepared for, is in many traffic courts, you don't have discovery. So this guy doesn't realize that, he's not prepared for it, and so this is what ensues.
File a motion, specific motion to dismiss, that's fine. But I don't see, let me see the file.
objection. I haven't seen any evidence, factual evidence of jurisdiction, of applicability of the law, court, or what.
You?
To me, yes, exactly.
Okay, well, that's been ruled on. Now for the fifth, sixth time?
Ruled
I
on
find
what?
the court has jurisdiction over you. You've subjected yourself to the laws of the state of New York by signing up for a license and a registration.
Can I
You're
see?
using the roads of the state of New York. You were issued a ticket. You came here to answer it voluntarily.
Sir, objection. Is that your arbitrary decision?
It's hardly arbitrary.
Okay, so what evidence do you rely on? Do you have
Sir.
any evidence? I haven't seen any evidence against
You
me.
don't, and you won't.
Why not? Are you hiding evidence against me?
The only evidence against you does not come from me, sir. That's the point.
Well, who does it come from,
It
sir?
comes from the prosecution, in this case, the officer. He's testified as to the facts and circumstances of the issuance of the tickets. You're in the middle of cross-examining him, sort of, and I'm just saying right now, if you want to prepare further for that subject matter, of cross-examination of the officer who's provided testimony against you, that's fine. If you'd like to continue, that's fine.
Objection. Nobody had provided me with any evidence.
I heard
He doesn't recognize evidence when it's told to him. The judge has told him the evidence over and over again, but they're not prepared for these types of situations when they arise because they've been told, you know, in essence, the only evidence that they would accept would be a signed consent form where they have consented to be subjected to these laws. Well, if nothing else, they've given implied consent the minute they get in their car and drive on the public roads.
evidence.
I haven't. I haven't seen factual evidence. It's all hearsay.
It's not hearsay. You asked the question whether it was on personal knowledge. So it's not hearsay.
Just, I haven't seen any evidence. I'm trying to, I was coerced here to come here for a trial.
If what you want to know is whether there are photographs or documents or things of that nature, there appear not to be.
Why was I not presented in timely manner with any information or evidence, and specifically factual evidence, that were supposed to be used against me?
He doesn't realize, it hasn't hit home yet, that the officer's testimony is evidence. Testimony, as well as documents, as well as pictures, as well as all this other stuff, is evidence. It's real simple. They just aren't prepared to understand.
Sir, I've been through your motion. I read through your motion. I made a ruling at the very beginning of this case that all the answers to your questions are contained within the accusatory instrument to the extent that they're proper.
Objection. Where on accusatory instrument it says it shows facts of jurisdiction.
It says that it's issued by the White Plains Police Department. It says that it occurred in the city of White Plains, in the state of New York. The location of the alleged offenses, the time of the alleged offenses, the vehicle of the alleged offense, your name, your ID number, your plate number, the date the registration expires, what the section you're alleged to have violated was, and a written explanation of what that section is. That's a lot of information.
Objection. Is that allegation, those allegations are the proof, a factual proof of jurisdiction?
Sure.
So alleging me of violating a code is in fact a proof of that code applicable to me and gives this court jurisdiction?
Not always, but in this case, yes. That's my ruling.
Okay, another reason to appeal.
Wouldn't be the first time. So do you want to continue with this trial or not?
Sir, I requested, I made a motion for any facts that the prosecution relies on against me. I made a Brady request. I was trying to determine what matter it was.
What? I'm sorry.
What matter this was, civil or criminal. I was trying to ask as many questions in order to understand these proceedings as possible. Now I feel that you prosecuting me instead of trying facts.
I'm responsible for your feelings, sir.
And I mean, there were a lot of reasons for me to believe that.
Let's do this for just a moment. What is it that's not on the accusatory instruments, two of the tickets, that you need to know in order to have a fair trial?
Sir, objection, but am I presumed innocent? So where can I get and when can I get, because I've been waiting for quite a long time, for the factual evidence, and they all listed right there what I specifically requested.
Apparently, the only evidence is the testimony of the officer.
Okay, but you're not letting me cross-examine the witness too.
I am, to the extent that the rules say you're allowed to. The rules of evidence.
Okay, so you said I have a right to fair trial. Is that correct? Okay. How is that this trial was scheduled today on my behalf?
What?
Well, you said the Judge Freya scheduled a trial.
All I know, sir, is that it was scheduled for a trial because you requested one. And apparently, had you provided some proof that the vehicle was repaired, tickets probably would have been dismissed.
Objection. How is that relevant to this matter?
Not relevant to the trial. We're at a trial now, so I'm asking you whether you want to continue.
Motion to dismiss for lack of jurisdiction and evidence.
It's denied.
On what grounds?
I already stated that I'm not going to do it again. We've been here for quite some time, and it's not that I'm losing my patience, but you're wasting the time of everyone in this court who should be doing their work.
I agree with you. I should have not been coerced into coming here.
Enough. Do you want to have a trial or not? I can very well make a ruling. If you do not want to continue, if you're done with your cross-examination, then you're done with your cross-examination, and I'll allow you the opportunity to testify.
I asked Judge Freya about was this matter civil or criminal. She stated it was civil. I requested a trial by jury in this matter. She denied.
Yes.
Why was I denied a trial by jury?
Can you show me where you're entitled to a trial by jury on a traffic ticket?
On the traffic, again, there's no evidence of this code applicable to me.
Is that because you are special?
No, sir, that I'm referring to the controversy.
What's the controversy?
Mr. Dennett here alleging me of violating
Officer Dene.
a code, right? Or law?
Traffic law.
Okay, a law. Okay. Now, since I haven't been provided with any evidence of that applicable to me, again, this is a question of jurisdiction.
You're not going to do this again, are you? Because I'm ordering not to read or tell me things you've already told me 6 or 7 times, and I've read your motions twice now.
Why is my right to a trial by jury is denied?
You don't have a right to a trial by jury. It's not that it's denied. You don't have one.
I don't have one. So you never gave an oath to support and uphold the Constitution of the state and United States of America.
That's not true.
Okay, he's about to go into a misinterpretation, misapplication of the 7th Amendment.
And don't cross-examine me. Cross-examine the witness if you wish to continue. Otherwise, this trial is over.
Sir, you just stated that I don't
know
have
what
the
I
right.
stated. Do you want to continue or not?
I was trying to continue. You denied my right right now.
Fine. Do you want to continue or not? I'm not denying anything. You continue your cross, but do not ask me any more questions.
I want a trial by jury in this case.
Denied.
Denied on what grounds?
You don't have a right to one. Should we
Yes,
do
I
this
do.
again? Where does it say you have a right to trial?
U.S. Constitution, Bill of Rights, Article 7, in suits of common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact.
Now, of course, this is not, a traffic ticket is not a controversy over money. So this is where the soft-sits misinterpret the 7th Amendment. 7th Amendment is federal, and it applies to civil proceedings where there's a controversy of, somebody owes somebody something. A traffic infraction is a low-level crime, and it's run by the rules of criminal procedure. And it's not an issue of somebody owes me money. It's an issue of was a law violated or not.
Tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law.
Okay. Very good. I get your point, and you can appeal my ruling.
Okay.
I really understand where you're going with this. But you don't have to keep repeating it. I really do understand what you're saying.
Well, so if you understand what you're saying and you deny my right.
Just because I understand it doesn't mean I agree with it. So, again, and for the last time, continue your cross-examination, testify, or we're going to draw an end to this trial. Those are your 3 choices, and do not follow this up by asking me questions.
Sir, I feel threatened in this court by you because you threatened me earlier of contempt.
Very nice. Have I helped
You also-
yet?
you
can
also-
answer after my repeated warnings. So, if you're not going to take one of the 3 options, would you like me then to rely only on what I've heard so far? What you don't have is the right to stop court in the middle of court by your antics.
I'm not stopping the court.
Yes, so then proceed.
You being an attorney for a witness.
Proceed. Or don't.
You keep.
If you do not proceed with cross-examination, I will deem that you have waived the right to further cross-examination.
Sir, I would like to proceed with the cross-examination.
Do it.
You keep stopping me all the time.
I said do it. Proceed with a relevant question, and I will let you proceed. Proceed with a question that is improper, and I will not.
Objection. Every question is proper and relevant to this matter.
That's not your ruling to make.
That's not my ruling to make. So you've determined your ruling.
I've determined each of my rulings and the rulings I've made. Yes, of course.
Okay, so right now you pretty much know where this court is going, this trial or
No,
whatever
I
you call
don't.
it.
I haven't heard the cross-examination, if you want to continue it, and I haven't heard your testimony.
Sir, I'm sorry, but how are you gonna hear the testimony if of the officer and cross-examination if you're not letting me cross-examine the witness?
Continue with your cross-examination right now, or you will have waived the right to further cross-examination.
Okay, I'll continue. Are you familiar with police term testifying?
I'm sorry?
Are you familiar with police term testifying?
Test to lying?
Yep.
No, I'm not familiar with it.
You've never heard of such a common phrase in the legal and police profession?
I have not.
It refers to the problem of rampant police
No,
perjury.
sir. You get to ask questions, not make statements. Cross-examination.
Okay, are you familiar what a Brady cop is?
I'm sorry?
Are you familiar what a Brady cop is?
No.
Have you ever been dishonest on the job, whether in court or out?
I'm not going to answer that on the grounds that it has nothing to do with pertaining to the situation at hand.
You've already asked this question. You're always honest. Yes, he's always honest.
Objection, you're leading.
I'm not believing. I'm making a ruling again. Move on, or don't.
Did you speak with anybody about this alleged law violation before today?
No.
Did you relay to court the facts you relied to prove I violated the law?
I'm sorry, say that again?
Did you relay to this court the facts you relied to prove I violated the law?
Yes, that was my testimony earlier.
And your testimony are facts of law violation?
Of your law violation? Correct.
Actually, you alleging me of violating your law. Or,
It's not my law, sir. It's the state of New York's law.
okay. As part of your job, do you investigate people for violation of the law and code?
As part of my job, that is correct. As a police officer, yes. That's what I'm sworn to do.
Thank you. Do you arrest people you believe they have violated the code?
It depends on what code says.
No, it's a yes or no question.
No, it's not.
Yes, it is.
Sir, move on.
Okay, non-responsive.
There's no arrest in this case. It's not relevant. There's no arrest in this case.
Okay. I object to that too. And you're honest in your investigation of violation of the code?
I'm sorry, sir?
And are you honest in your investigations of violation of the code?
Of what code are you pertaining to?
Particularly in the one you alleging me of violating?
Am I honest on the code of the violation I issued the 2 summonses to you? Yes.
If there isn't sufficient evidence to prove a violation of the code, you would not issue a complaint against me?
I'm sorry, I don't understand the question.
If there isn't sufficient evidence to prove a violation of the code or law, would you not issue a complaint against me?
I'm sorry, but I still don't understand the question.
Sir, is the question whether he would, if he thought that there wasn't a sufficient violation, he wouldn't issue a ticket?
Let me try to rephrase
I
it.
think neither one of us understood it, so
Okay.
try again.
Let me separate in a few questions. Do you rely on evidence to prove the violation of the code and law?
That is correct.
Okay, so do you have to have sufficient evidence to prove that?
That is correct.
Okay, so if there isn't sufficient evidence to prove a violation of a code or law, would you not issue a complaint?
That would be correct.
Do you hold an objective standard of proof?
To whom or what?
Do you know what the question means?
I'm thinking it's pertaining to him, but I'm not
Well,
really certain.
let's don't guess. What do you mean by that question, sir? Objective standard of proof. What does that mean?
Well, what I'm asking here is that do you have standards? Do you have your own standards of proof that you rely on to present that you're presenting in court against me in these allegations?
The standard would be the summons I issued you.
So these standards, the standard of proof, you apply to everybody who you alleging of violation of a law and code?
I'm sorry, can you rephrase that? I don't understand a little better.
Yes, sir. So you just referred to a complaint that's being a standard of proof in a code and law violation, correct?
I still don't understand the question. I refer to your summonses issued to you and the day that I issued you them as a standard of proof.
Standard of proof.
Correct. I believe you got 2 copies the same day, correct?
No, I'm sorry, but I'm cross-examining the witness.
No problem.
I got that. I made that ruling, sir.
Were you the one who charged me with violation of the code? Correct?
Which code?
The one on accusatory instrument.
Are you
For
referring?
the record, I'm showing the officer the summonses.
No, I'm asking you, you probably,
Are you the
I understand what you're saying.
accusing officer?
Are you referring to Vehicle and Traffic Law 375-34 with your rear reverse light out and Vehicle and Traffic Law 375-12AB2 front driver and passenger side windows tinted? Is that what you're referring to?
I'm referring to the code. I don't know the code and I'm not enforcing it. So I'm just
Is he
asking,
the officer who's accusing you? Is that your question?
yes, if he's the one who's accusing me of violation of this code.
I am the officer accusing you of the violations of the summonses issued to you. Correct, on the October 22nd of 2013.
Thank you. You determined on your own the code applied to me?
That is correct.
And you determined on your own I violated the code?
That is correct.
And are you certain I violated the code?
You operated the vehicle the day that the summonses were issued, so yes.
So it's a yes answer, correct?
That's what I said at the end of my sentence.
Thank you. Are you qualified to determine on your own I violated the code?
Yes, I am.
Are you an expert in interpretation and application of the constitutional laws?
So that's not the question. everything that you were asking. You were asking about summonses that were issued to you. He doesn't have to be a constitutional expert in order to do that.
Okay, let me rephrase that. Are you an expert in interpretation of application of codes and laws?
Yes.
When you determined I was subject to the code, was it based on facts or was it arbitrary?
It was based on facts that what I observed.
What facts do you rely on to prove the code is applicable to me?
I'm sorry, say that again?
What facts do you rely on to prove the code is applicable to me?
Facts that you're operating a motor vehicle in New York State, so you're subjected to the vehicle and traffic law of New York State, which you violated on that day.
And is there a factual connection between code and law and me?
I'm sorry, say
He just gave him the connection. The mere fact that he was operating a car, motor vehicle, automobile, whatever you want to call it, on the public roads. That's the nexus. That's the triggering event that makes him subject to those traffic laws.
Is there is factual connection between code, law, and myself?
I'm still not really understanding your question.
Okay. Well, you answered a previous question. You rely on facts to prove the code applicable to me. So I'm asking if there is factual connection between the code and law and me.
If you were operating the motor vehicle the day that I observed your reverse light out and your tinted windows out, then yes, the code would be connected with you because you're the operator at the time.
Could you please clarify this only facts?
Clarify that.
The facts that you rely on.
What I observed.
So your observation is the fact that connects the laws and codes and me?
Correct.
Did you witness me within the state?
Yes.
Oh shit, I hope we're not going to go down this heretic type rabbit hole here.
Is that an arbitrary opinion or is it based on facts currently within your knowledge?
I'm going to go out on a limb here and take judicial notice that the city of White Plains is within the boundaries of the state of New York.
Now there's something that this Mr. Medvedev totally misses. The judge is taking judicial notice of the geographic location.
Objection. Are you answering his question?
I'm making a ruling. Move on.
What is the state factually?
You don't have to answer that. It's a philosophical question.
Objection.
Good. Move on.
And it is. Mr. Jeheretic, who likes to say you can't be in the plaintiff. You can be in it if you're buried in the ground, this type of stuff. They don't understand that it is a philosophical question and issue, what the state is.
So noted.
You're being unfair.
So noted.
Did you witness me committing a code violation?
Vehicle and traffic law code, yes.
Is that a crime?
That is a vehicle and traffic law crime, correct?
How many elements are in this crime?
I'm sorry?
How many elements are in this crime?
How many elements are in the fact that you had a reverse light out and your windows were tinted?
See, this is the thing is traffic infractions are what's called strict liability crimes, if you will. There's no intent, no state of mind, no mens rea element to it. There's basically two elements to strict liability, that there was a law and you were observed violating that law. Those are the two elements, a law and an action.
Is that what you're asking?
I'm just asking to determine, to respond to me, how many elements are in this crime?
Can you define elements?
Stop, please stop. That's a legal question. It's not a factual question.
And why I cannot ask him a legal question if he's making legal
Because
conclusions?
it's not up to a witness to determine what the law is.
Well, he's the one who made a complaint against me. He's the one who determined, he just stated, he determined that code and law is applicable to me.
Yes.
And why I can, so it's his legal conclusions.
No, it's a factual statement. It's my conclusion whether it violated the law, whether what he observed violated the law.
Okay. So is he not competent to answer that question?
I don't believe so. I don't think it's
Are you
permissible.
competent in answering that question?
Sir,
Yes, sir.
it is up to the people to prove each and every element of an offense charged. Whether they've done so is a determination for the fact finder. In this case, I'm both the finder of the fact and the law. And so I will determine at the conclusion of the case whether his testimony satisfies the elements of the crime.
Let me understand this correct. He knows these facts, you know these facts, and I don't know these facts.
You really don't?
I'm asking you because you're the one who's making this ruling right now, and I'm the one who's trying to cross-examine the witness.
Continue. Your objection's noted.
All right, I'm finished.
We have the from Mr. Medvedev. Do you wish to testify?
Nope.
Well, in charge of violation of section 375-34. Which states, and these are the elements of the offense. Any motor vehicle may be equipped with, and every passenger vehicle registered in this state and manufactured or assembled after January 1st, 1969 shall be equipped with at least one backup light. Such light shall display a white light to the rear when the ignition switch is energized and the reverse gear is engaged. Such light shall not be lighted when the motor vehicle is in forward motion. According to the testimony, your rear reverse light was not functioning. So I find you guilty of that charge. The other charge is 375-12A-B2. A of 375 is as follows. Every motor vehicle except a motorcycle, when driven or operated upon a public highway, road, or street, should be equipped with a front windshield and fixed in more or less upright position, constructed of safety glass, as defined in subdivision 14 of this section and required by subdivisions 11 and 12 hereof. No person shall drive any motor vehicle with any sign or other non-transparent material other than a certificate or paper required to be displayed by law upon the front windshield or the side wings or side windows on either side forward of or adjacent to the operator's seat. That's 375.12a. A, you're charged with violation of section 375.12a, A2, I believe. I'm sorry, B2. Subdivision B indicates no person shall operate any motor vehicle upon any public highway, road, or street. I'm referring to number 2, the side wings or side windows of which, on either side forward of or adjacent to the operator's seat, are composed of, covered by, or treated with any material which has a light transmittance of less than 70%. The only testimony I've heard in that regard is that the officer couldn't see you. I don't believe there are sufficient facts for me to ascertain whether it was less than 70% that your windows were allowing through, so I'm finding you not guilty of that one. This is from 2013, the 10th month.
15.
So with respect to your conviction of 375.34, and that's with respect to ticket number BD0823266. And again, ticket, I'm sorry, that's correct. That's correct. And ticket BD0823292 is dismissed, not guilty after trial. All right, sir, just give me your name at the window and take care of the fine and surcharge, please.
Where do I get information about the appeal?
At the window.
At the window.
All right, Visa, MasterCard, Discover, or cash.
Thank you.
Okay, so this doofus wants to appeal. Now this case was so simple. He could have put a fucking light bulb in his backup light socket and that would have been dismissed. He could have simply also said, Judge, there's no evidence, no proof that the tint on my windows meets that 70% threshold. That would have been dismissed, and it was dismissed. So now he's got a ticket that exceeds way more than a backup light would have cost him. So anyway, I hope you enjoyed it. I hope you're not too drunk. And if you like these type of videos, please like and subscribe. Thank you very much.